Hi, my name is Sasha Struthers. I'm an employer defense attorney here in Los Angeles. I'm doing a video today on what an employer should do and expect when they get a notice of claim in conference or a notice of hearing regarding an employee who has filed some claims regarding wage and hour violations with the Labor Commissioner's Office. I will preface the Labor Commissioner's Office, also known as the Department of Labor Standards Enforcement, is a branch of the Department of Industrial Relations, because in California there's just a penumbra of employment agencies. So this is oftentimes what I call the labor board. And the labor board has very limited jurisdiction. They only hear employee claims about minimum wage, overtime, meal and rest breaks, piece rates, commissions, business expense reimbursements, sick and vacation pay, and the civil penalties that go with all those, including if you have incompliant wage statements. And there's two ways that the Labor Commissioner's Office investigates claims. Either the employee files a claim, which is the most common, and what I'm going to talk about in this video today, or the Commissioner's Office themselves does their own investigation, opens their own claim, which usually happens because someone tips them off to it. So to begin, one of the first steps, or the first thing that happens after the employee goes to the Labor Commissioner's Office and files a claim, is you'll get a notice in the mail of claim in conference, which basically tells you your employer has filed a claim against you and you have to come into the office and talk about it. In this meeting you have, which usually going forward might not always be virtual, but it's historically been that you come together and you meet and you talk about, potentially settling these claims. Yes, the employee is claiming they didn't get paid correctly, and the employer is obviously going to argue that that's not the case. The tricky thing about a claim in conference, or with really this whole process in general, it is heavily in favor of the employee. So during this, if you don't settle it, which the commissioner will ask that both parties go into different rooms and they'll try to mediate and settle this case with whatever time they can, because they have, all these appointments are stacked. If you don't, the parties come together and then talk about the claims. You want to be present as much as possible with the commissioner and the employee, because if you're not, what often happens is the commissioner will talk to the employee one-on-one and start adding even more allegations to what the employee initially was going to claim. So at the claimant conference, it's pretty informal. You talk about the allegations and you try to settle it. If you don't settle it, then a complaint is filed, and then the case is set for a hearing. Hearings are usually 6 to 12 months out, could be longer. They're very, very backed up. They always have been very backed up. You can, by all means, try to settle this case with the employee before a hearing happens. It just kind of depends on circumstances, how friendly the employee is, if you have representation, and the severity of the allegations, and really how much they're asking. So if you don't settle it, you go to the hearing. The hearing is a mini trial. I say mini trial because it's not a jury, it's not that formal, but the hearing is the trial. And it'll be the employee, the employer, any witnesses both sides brings, and then respective documents to prove or disprove the allegations. And it's done before a hearing officer. It's in the same rooms that you have the claimant conference, and you try to mediate there. At this point, you can also try to settle the case. And at any point, it's highly suggested to settle the case, because again, the Labor Commissioner's Office sways entirely in favor of the employee and gives the employee the complete benefit of the doubt. So if you don't settle and you go through the entire hearing, then the hearing officer will issue a judgment. They'll issue their findings, and that's a court enforceable judgment. And that's as good as if you went to, what is considered like civil regular court. So you want to be very careful of that, because in all steps of this entire process, from when the employee goes and files a claim to like the day of the hearing and the decision's rendered, all of it's in favor of the employee. And if you don't know or you don't have representation, you oftentimes end up overpaying, or the allegations get drastically inflated because you yourself as the employer don't know or don't have the typically the negotiating skills to handle these things with the labor commissioner, because simply the labor commissioner will railroad you and pretend that they're like unbiased and they're neutral when they're really not. So it's always suggested that you talk to an employment attorney like myself when you get notice of a claimant conference or you get notice of a hearing. This way, at least you understand your liability and your exposure, and you can try to mitigate it before you have a court judgment, which is the result of the hearing. So should you get a claimant conference notice or a hearing notice, by all means, please call me or email me. My information will be in the description box, and we could talk about the steps, the potential liability, ways to try to settle it, to mitigate going forward with potential other employees. Because like all things, once one employee comes forward, it tends to snowball depending on the work environment. So you should talk to an attorney as soon as possible when you get either, again, a notice of claimant conference or a hearing. I hope this video was helpful. And should you have any questions, by all means, again, contact me. My information will be below. Thank you.